Let me go see who I've got in here. All right, good morning, everyone. Sorry, it's taking me a second to make sure everyone is set up in the online courtroom, and we may not have everyone, but I think that we do. All right, the court's going to call this morning's docket. Ask for appearances. Please say present here, raise your hand so that I can acknowledge you for the docket. Good morning, Mr. Head. How are you, sir?
Good, Your Honor. How are you today?
Hey, I'm good. I'm sorry. I had everyone but you. I had a couple of people in the waiting room, and I didn't recognize the name until the last second. So I was going to call the first case just for acknowledgement of being here, and realize that you were on that case. So call CR 1950, CR 1949, Brandon C. Broderick. And obviously, Mr. Head is present online. And is Mr. Broderick here?
Your Honor, he is actually here in the office with me. I'll pan the camera around. This is Mr. Broderick.
Okay. All right. Then the record will reflect that Mr. Broderick and counsel, Mr. Mike Head, are appearing via Zoom this morning. And I believe that today we were set for a waiver of jury trial. Is that correct, Mr. Head?
It is, Your Honor.
Okay. And state, is audio and visual okay for you?
Yes, sir. We can hear.
Okay, excellent. All right. So I had previously seen the waiver of jury trial in this case. However, I asked Ms. Taberham to ensure that it was set so that we could discuss this on the record in open court in compliance with the law. So, Mr. Head, do you join with your client, Mr. Brandon Broderick, in requesting the court to waive his right to a jury trial?
I do, Your Honor. I've gone over the waiver with him, and he understands what he's waiving and the consequences, and I join in that with him.
All right, Mr. Broderick, if you will, raise your right hand, sir. I'm going to place you under oath and ask you a couple of questions. Mr. Broderick, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, and the audio is a little bit muffled, so make sure that you speak up and towards the microphone as much as you can. Mr. Broderick, do you understand that you have the absolute right to have a trial by a jury of your peers?
Yes, sir.
And you understand that the only one that can waive that right is you. Mr. Head can't waive that right. The court cannot take that right away from you, and the state of Texas cannot take that right away from you. Do you understand that? And say that, and go ahead and say that again. We didn't hear anything on this side.
Yes, sir.
Okay. And Mr. Broderick, you understand that by waiving your right to a jury trial, you're also waiving your right and opportunity to cross-examine the state's witnesses and its evidence before a jury. You understand that as well?
Yep.
And you've had an opportunity to speak with your attorney, Mr. Head, regarding the importance of whether or not you should waive your right to counsel. Is that correct?
Yep.
And has anyone threatened you, forced you, or otherwise pressured you to waive your right to a jury trial?
No, sir.
All right, Mr. Broderick, are you telling me that you are intentionally, knowingly, and voluntarily waiving your right to a jury trial and asking the court to approve the same? Is that a yes?
Yes, sir.
All right. And does the state of Texas join in with Mr. Head and his client in consenting to the waiver of a jury trial?
We do, Your Honor.
All right. Then the court this day finds that Mr. Brandon Broderick has intentionally, knowingly, and voluntarily waived his right to a jury trial. The court will approve the waiver of the jury trial. And how are we going to proceed in this case now, Mr. Head?
Your Honor, it was my understanding, I know Mr. Cox and Mr. Weiner have visited on several occasions, and I've also spoken with them, that we were going to set this for an agreed plea disposition in approximately 60 to 90 days. Mr. Broderick is working and trying to put back some money for his family, and that when he does enter a plea, he is going to be going into custody for a period of time. And so we were hoping maybe the virus issue would be settled down a little bit so that he would be able to be transferred to TDC rather than be held in county when he actually goes into custody.
In state, do we know if TDC is accepting inmates at this time?
Judge, it's my last understanding that they are slowly but surely beginning to accept inmates. I believe the number I heard was half of what they normally take. And I believe that's starting on July the 1st.
So Mr. request was 60 or 90 days. Was that right, Mr. Head?
That's correct, Your Honor.
And state, do you have a position on that?
Judge, we're okay with 60 days. That is the, that's what I communicated with Mr. Weiner about.
All right, then we'll set this for a plea on August 4th. Mr. Head, are you available on that date? That'd be a Tuesday.
Yes, Your Honor, that would only, I think August 4th would only be about 35 days, wouldn't it?
Oh, I'm sorry. What are we in? We're in June, July. I'm sorry.
Or with me, you don't, I do.
What about June, July, August? How about September 15th?
Yes, sir, Your Honor, September 15th would be fine.
All right, then the court sets this for a plea on September 15th, and this will be the only notice that you receive, Mr. Broderick. You understand? Mr. Broderick, do you understand that?
Yes.
And I apologize, Your Honor, we've lost video on this end, so the bad connection may be on our end, so I apologize.
That's okay. So Mr. Broderick does understand that he is due. He's ordered to be back in the court on September 15th. That is a Tuesday at 9 a.m. to negotiate his plea.
Yes, sir, Your Honor. We did hear the court. I've made a note of that, and Mr. Broderick is aware of that. We had just one other brief issue, if we could ask. The court had placed Mr. Broderick on pretrial reporting. He's been reporting weekly. The court had indicated at that time that if everything was going well, it might allow him just to report monthly so that he could not have to miss a day of work each week. And we just wanted to ask if the court might consider between now and the 15th, allowing him to report monthly rather than weekly.
Is there any position by the state?
Judge, I'd have to speak with probation first before I could agree to anything, and I've not spoken to probation about that request.
Mr. Head, Mr. Broderick be allowed to report monthly rather than weekly. We have him on concurrent conditions of pretrial release. And if you'll do me a favor, come on around here and just hop in front of the thing, and then you can give me that way Mr. Head and Mr. Cox can see it. There you go. You see. So, all right, can you give me a status update on how Mr. Broderick's doing on pretrial release?
Judge, her microphone's on mute. We can't hear her.
Well, she's going to be speaking through my monitor.
Okay.
Otherwise, we'd have a feedback loop. And she's not talking yet. That's why you can't
Oh,
hear her.
okay. That's why I can't hear her then.
All right, so she needs a moment to check. So if we'll just stand by, Mr. Head, then we'll come back and revisit this, okay?
Yes, sir. Thank you.
So I'm going to put you on mute for just a second.
Yes.
Because Heidi put probation base on it. I did not do that. He did. So she's just gonna send. That's why I want you to know I didn't do that. She put delinquent probation base on it.
So they're just going to redo it?
They're gonna read that
Okay.
front page.
Okay.
Do you wanna wait?
Yeah, let's wait.
That's what I think. Thank you. She's supposed to email it. Thank you, sir.
You're all right, State, do you have any witnesses sitting in the online waiting room? I have, it looks like maybe Investigator Will Jones, Bob Keltner. Does anyone know who Tom Thompson is? Mr. Green, is that your witness?
Judge, he's the state's witness. Well, it's the case that Mr. Green is here on. It's State v. Sean Palmer. Ms. Melantree had previously represented or currently represents Mr. Palmer. Mr. Green's filed a motion to substitute. We thought we were having a hearing today with Ms. Melantree, and we had subpoenaed Mr. Thompson to appear as a witness. However, it appears we're not going to be having that hearing today.
Well, let's, Miss Melantree's here in the courtroom and she's making her way up. And Mr. Palmer, you can, I see you. I've noted you for the record. You can just stay where you are, okay? Yes, please. You can, they're here. Come to council table. Good morning. How are you? Okay. Court is calling CR 15487, State versus Sean Anthony Palmer. Record will reflect that Mr. Palmer is present in the courtroom. And the court has before it a motion to substitute counsel wherein Mr. Steve Green is asking the court to substitute in as counsel for Mr. Palmer. And the court had previously appointed the Honorable Beverly Melantree to serve as court-appointed counsel. Ms. Melantree, do you have any objection to the substitution of Mr. Green?
No, I believe I saw it before.
Okay, and State, is there any objection to Ms. Melantree being removed as counsel and Mr. Green being substituted in?
No, Your Honor.
The only issue for the court is, before I would grant that, is any fees being owed to Ms. Melantree.
No, Your Honor.
Are you going to be charging the county anything, Ms. Melantree?
No.
And how long did you represent Mr. Palmer?
I believe I was appointed. Do you have any knowledge?
I don't have it open with me.
Initially, I was appointed to him in jail hall where I had other clients. So we were able to represent a client. I believe it was about 3 months ago. I have made one appearance regarding this case with Mr. Palmer, but every time I would come, I had other clients. So that's no need for me to charge them.
Okay. All right. Then if the only issue for the court was if Ms. Melantree was going to charge the county, it's my policy to have the defendants pay that before we substitute in retained counsel. So Ms. Melantree has stated for the record that she is not going to charge Van Zandt County for the indigent appointment counsel fees. Therefore, the court, having no objection from the state, hereby grants the motion to substitute counsel and enters Mr. Steve Green's appearance into the record for Mr. Palmer. And I believe that we were set today on the motion to adjudicate. And I'm assuming, Mr. Green, that you are ready to go.
Judge, I didn't realize that there were witnesses subpoenaed. So I would ask the court to at least give me 30 days to prepare for that. I did visit with Mr. Cox this morning. I sent an email to the DA's office last week asking for a copy of the motion. I hadn't heard anything back. Mr. Cox and I have communicated this morning. And he indicated that he would have it to me later today. I just need some time to review that and have a chance to prepare for any hearing that may be necessary.
Okay. Then what the court is going to do, I'm going to administer your analysis test on Mr. Palmer. And I'm going to go ahead and grant the reset, but I'm going to conduct a urinalysis to determine, to see if he's clean. If he's clean, then we'll reset and he'll stay on bail. If he's not clean, then he'll be going into custody today.
Yes, sir.
All right. So Mr. Palmer, you come on up here and have a seat. And if you can, ask Mr. Waddell or Mr. Gann to come and administer UA on Mr. Palmer and then report back to me. Mr. Green, do you want to stay and wait for the return of that, or would you just like to be contacted by the state or the court?
If y'all could just contact me, that would be fine, Judge.
Okay, so let's go ahead and set this then. You said 30 days, Mr. Green?
At least 30, Judge. I'm going to be out about starting next week for about a week and a half. So maybe that last week in July or that first week in August. Preferably that first week in August if you have something.
Well, I would be setting it for a contested hearing. So the next available contested hearing date would be August 23rd. I'm sorry, it would be July 23rd, or it would be August 27th, July 23rd or August 27th. Could you make the 23rd?
Judge, I can't. I'm going to actually, and I misspoke when I spoke to the court. I'm waiting to hear whether I have to be at a conference in Birmingham, Alabama, starting the 23rd. Either way, if I don't have to be there, I'll have to be hearing via Zoom for that conference. And I actually had forgotten about that. So that August the 27th date would be the best. And I'm going to visit with Mr. Cox to see what we can do to resolve it without the need for a contested hearing.
Mr. Cox, any objection to August 27th?
No, Your Honor.
It's a little later than the court would like, but that's the next available that Mr. Green's available for.
That's fine with the state.
All right, then the next hearing will be August 27th at 9 a.m. And that'll be on a motion to adjudicate.
Yes, sir. And Judge, there should be an order in your file for the motion to substitute. Set a proposed order when I file the motion.
Yes, sir. I've seen that, and I will
Okay.
retrieve that, and I'll sign that and have a copy sent back to you.
All righty. Appreciate it, Judge.
Yes, sir. Thank you. And I'm going to go ahead and notate my docket for August 27th for contested MTA. And then we'll contact you regarding the results of your analysis test.
Yes, sir. May I be excused?
Yes, sir. Thank you, Mr. Green.
Thank you.
Have you had a chance to check on Mr. Broderick? All right, the court's going to revisit Brandon Broderick and the request to report monthly rather than weekly. Ms. Burns has indicated to the court that after consulting with Mr. Broderick's officer that he is reporting, he's in compliance. There's no known issues, and the probation department has no objection, Mr. Cox.
Thank
Judge,
you.
in that case, I'm sorry, Judge, has the court made a ruling? I didn't catch that.
No. Ms. Burns has indicated that there is no concerns from their standpoint. He is reporting, he's paying, and doing what he's supposed to do.
Okay. In that case, Judge, I'd agree to bi-weekly.
Mr. Head?
Your Honor, we were just hoping to make it monthly so that he could get in more days at work between now and the time that we have the next court day.
All right, then go ahead, Mr. Head.
I'm sorry, Your Honor. I was just going to say he has to miss an entire day's work each time he goes in to report. So that's the only reason for the request.
All right, the court will grant the defendant's request and will modify the conditions of pretrial release, requiring Mr. Broderick to report monthly as directed by the Van Zandt County Community Supervision and Corrections Department.
Thank you, Your Honor.
So we'll get that modified, and Mr. Head will email it to you to provide to Mr. Broderick. And he'll get a copy the next time that he reports. And so he'll need to contact his probation officer about his next report date.
Yes, sir, Your Honor. He'll do that immediately.
All right, then we'll see you back on September 15th for the plea then.
Yes, sir. Thank you, Your Honor. May we be excused?
Yes, sir. Thank you, Mr. Head.
Yes, sir. Thank you.
Mr. Cox, I believe that Mr. Thompson has left the waiting room, so I assume that you have contacted your witness about not needing him for.
Yes, sir, we did.
All right, and also see Investigator Will Jones and Bob Keltner, Investigator Bob Keltner in the waiting room. Are we proceeding with a hearing today with their testimony?
Yes, sir, that's on a writ filed by Mr. Manning on Courtney Odom.
Okay, all right. Okay. All right, and let's see, Mr. White, let's go ahead and we'll make an announcement on Mr. Chad Derek Williams, CR 16288. We are set for a status of records today, and the record will reflect that Mr. White had indicated to the court that Mr. Williams had some concern about whether or not he had been potentially exposed to the COVID virus, and the court has seen Mr. Williams today and instructed counsel that Mr. Williams would not be required today on the basis that there appears to be an agreement between the state and defense on.
That's correct, Your Honor. Mr. Williams contacted me late yesterday after time we kind of got it all sorted. It was after.
Judge, we can barely hear Mr. White.
If you'll just go to the podium and into the microphone, then maybe that'll help. Mr. Cox says he can't hear.
Your Honor, shortly right before close of business yesterday, Mr. Williams contacted my office, made me aware that he believed that he had been in contact with somebody who had been diagnosed with COVID-19. I guess because of HIPAA regulations, his business refused to tell him exactly who it was, so he was unsure. He knows that there was a positive case where he works. So out of caution, I had him show up today. He was standing outside, and I showed you where he was standing. Previously, I talked with Mr. Cox on this case. We were trying to get some medical records. We got those records. States indicated to me that they would be agreeable to a reset, that this would be the last one. I had no objection to that. The court said that when it's ready, we'll be ready to go.
Mr. Cox.
Yeah, Judge, I caught that. That's correct. It's the state's understanding today's setting was for status on the records. As Mr. White said, he's received the records. So at this point, the state's ready to have a hearing as soon as the court is ready, willing, and able to grant us a hearing.
All right, so let's set this then for contested hearing on July 23rd. Mr. White, you available on that date?
I'm going to be here.
State, any objection to that scheduling?
No, Your Honor, July 23rd is fine with the state.
Okay, all right, then we'll set this for evidentiary contested hearing on July 23rd. And the court will let the record reflect that Mr. Williams was excused from appearing inside the courtroom, and the court viewed him outside the courthouse. And so Mr. White asked that you send notice to your client that he's expected to be here he's ordered to be here on July 23rd.
I will, Your Honor.
Mr. White, what's the announcement in CR 16391, State versus Damon Scott Watson? Is Mr. Watson here?
Yes.
All right, thank you, Mr. Watson. Go ahead, sir.
On this case, Your Honor, the state had made us an offer. I communicated that offer to my client. Subsequently, state informed me that we were going to have to maybe go forward on the hearing. They provided me with some additional information, I believe on June the 18th, on or about that day. I reviewed that information, got in touch with my client due to the work schedule. I got him in late last week. We discussed what was going to happen. I talked to a witness yesterday that we might need. So I'm not prepared to go forward today. I don't need very long. I just try to get everything done on the government.
State, any objection to the request for a reset?
No, Your Honor, Mr. White and I discussed that last week. We did provide him with new information. We filed 404B evidence, which changed the nature of our offer. So we agreed to give Mr. White a little bit of time to go over that new information and the new offer with his client. Perhaps that July 23rd date would work for everybody as well.
Mr. White, to July 23rd.
That's fine. They'll give me some extra time. I'm okay with that. They'll be ready to go already.
All right, Mr. Watson for contested evidentiary MTA/MTR hearing on July 23rd. All right, Mr. Watson, you're free to go. We'll see you back on that date. All right, Mr. Schmidt, are we having a hearing today on your writ?
Judge, actually, I need to hold my my writ application in abeyance. I got here this morning and it turns out my client is apparently suffering from some sort of acute mental illness, and she is not really in a state to be brought before the court at this point in time. I would make an oral motion for competency. I'm not certain that the code permits that. If it doesn't, then I'll file one to see if we can get her evaluated. She's exhibiting severe mental symptoms at this point in time. So I'm not asking to withdraw the writ, but I'm asking to hold it in abeyance and see if we can't get her evaluated.
All right, then the court will reset the writ, and as the court policy is, Mr. Schmidt, just ask that you file an affidavit supporting the request for a competency evaluation, and perhaps speaking with jail staff will give you additional facts to provide to the court.
Judge, if the court would permit it, the information that I've gleaned is from Captain Smith here at the jail. He's with me and willing to provide testimony. And I found out this morning, so I'm not trying to spring this on the court or the state, but the information that I've gotten is not firsthand. It's from Jail Administrator Captain Smith.
Okay.
If the court wants to hear it.
Yeah, is he there with you?
He is, Judge.
All right, let's have him step up there.
Thank you.
Morning, Captain Smith. How are you?
Morning, how are you, sir?
Doing good. If you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God?
I did.
Go ahead, Mr. Schmidt.
Thank you. Captain Smith, we spoke this morning about Ashley Wilkins, is that correct?
Yes, sir.
And you had made some comments about her current status to me and your concerns about her behavior and her mental health, is that correct?
Yes, sir.
Could you describe for the court some of the behaviors that she's exhibiting that are of concern to you? And then we'll go from there.
Yes, sir. At least 2 to 3 times a week, we'll have to enter her cell from where she has banged her head against the wall. And then once she begins to bleed, she will smear the blood all over her, all over the wall. She'll defecate in her cell on the trays, on the food trays. She will smear the feces all over the wall. She continuously floods her cell with sheets, towels, blankets, shoving them down the toilet, the mat from the stuffing from the mats. And then she constantly screams and yells, and outside normal, just don't want to be here, jail behavior.
And Captain Smith, she was booked into your facility on May 4th of this year, correct?
It sounds correct. Yes, sir.
Has she progressively gotten worse as far as her behavior is concerned?
Yes, sir.
Do you think that at this point in time, she needs to be evaluated for competency?
Yes, sir.
All right, I'll pass the witness, Judge.
Any questions from the state?
Just a brief follow-up, Your Honor. Captain Smith, do you believe at this time that she is a danger to herself or others?
Sometimes when she bangs her head on the wall, yes, ma'am, I would say she is a danger to herself.
Or we pass a witness?
All right. Can someone tell me what Ms. Wilkins is charged with?
Judge,
Go ahead, Richard.
Judge, she's got 3 pending charges. She's got assault against a public servant during a declaration of disaster, failed to ID, and disorderly conduct.
So is the felony assault against public servant?
Say again, Judge?
Is the felony charge, the only felony charge, assault against a public servant?
It is, Judge, and I believe that was enhanced due to the disaster declaration. I don't think that, and I don't have any of the discovery. The state obviously should have that, so I'm not certain whether or not it was, I'm not certain the nature of the assault.
And how long has she been incarcerated?
Since May 4th, Judge.
May 4th? In
I
the
show
state,
57 days, Judge.
57 days. And it is the state's intent to take her to a grand jury and proceed with prosecution before the court pays $500 to have her evaluated?
Your Honor, the grand jury met last Friday. Ms. Wilkins' case was presented to the grand jury and they returned to Trueville. I'm sending discovery to Mr. Schmidt right now as we speak.
All right, so the state does intend to go forward with prosecution before the taxpayers pay $500 to have her evaluated. My point is, I don't want to pay $500 and then it be, we dismiss the case, or there's going to be an agreement to release on bail and let her treat herself through her private network of physicians. I want to make sure that we don't have that before I grant a taxpayer order to pay.
No, Your Honor, she's been indicted. The state intends on proceeding.
All right, then, based on the evidence before the court will grant the order to have Ms. Wilkins evaluated for competency under 46B. And Mr. Schmidt, the court will prepare an order for that evaluation, and I'll sign it and have it circulated to you and Mr. Cox.
Thank you, Judge.
All right, anything further, Mr. Schmidt?
No, that's all I have, Judge.
And then we'll get her evaluated. And I'm sure you'll be receiving some kind of notice from Ms. Tabraham on when that's set for arraignment, and we'll take the status up on her competency at that time.
Yes, sir. Thank you.
All right, thank you, Mr. Schmidt. All right, Miss Thompson, are we ready to move forward on Mr. Donald Ellis?
Yes, sir. I'm present and ready.
All right, is Mr. Ellis in the jail court?
Yes, sir. I'll go get it.
Okay, thank you. Yeah, if you'll go ahead and bring Mr. Ellis up. And while Ellis is John Charles Williams. Oh, John Charles Williams is in jail. Disregard. Sending Mr. Williams, Ms. Odom, Mr. Dunn, Mr. Ellis. All right, Mr. Ellis, how are you today, sir? Can you hear me okay?
Yes.
Okay, good. And can you see your attorney, Ms. Thompson? You got to say yes. Okay. All right. All right. Court call CR 19-305 State versus Donald Brian Ellis. And I believe that we were set today on a status for DNA. Is that correct, Ms. Thompson?
That is correct, Your Honor.
And do we have any update for the court on whether or not we have that result?
I'll let Mr. Cox explain that to you, Your Honor.
Judge, we did receive a lab report back from Swifts. It was either last week or the week before. We have received a report. However, the report is inconclusive. Ms. Thompson and I have discussed that report. I reached out to the analyst at Swifts in Dallas to go over it with him. I shared his interpretation with Ms. Thompson. The analyst informed me that there is perhaps some additional enhanced testing that could be performed that perhaps would lead us to a result that was not inconclusive. I reached out to the powers that be at Swifts to inquire into performing that testing. I have not yet heard back from Swifts as to whether or not that can even be done. Additionally, in this case, there is a psychological evaluation being performed on the victim. A part of that psychological evaluation was some school records that Dr. Andrews requested that we subpoena from Grand Saline ISD. We got a subpoena, we got those records from Grand Saline. I provided those to Ms. Thompson. She has copies of those school records. They were given to Dr. Andrews. At this point, we're just waiting on him to complete his psychological evaluation. So at this point right now, we have the DNA report. It's just a matter of, is there additional testing that could be done on the DNA? And we're also awaiting the psychological evaluation on the defendant. But as of now, as it stands right now, Ms. Thompson has been provided everything we have.
How long, Mr. Cox, do you anticipate for the psychological to be concluded?
I would say not much longer.
What does that mean?
Perhaps within 30 days. That was a vague answer. Perhaps within
Okay.
30 days.
I didn't want to object because I'm not supposed to do that anymore, but okay. And so, Ms. Thompson, is there any objection then to resetting this case once again for status of the psychological report? I'm assuming you're going to want that before you announce to the court whether or not you can reach a plea agreement in this case?
Absolutely, Your Honor. The only thing further that I would ask is as soon as Mr. Cox finds out about the additional necessary testing on the DNA, if it needs to be done, that he'll let me know as soon as possible.
Of course.
All right, then the court set this case until August 4th. August 4th. And we're going to do status on the psychological evaluation of the victim. I'm not going to continue to set it for status of DNA because we have that. I think at this point, it's just going to be whether or not the state wants to pursue additional testing, which would have to be announced to the court. So as far as pretrial, we're waiting on the psychological evaluation of the victim, and we'll do a status on August 4th. And that will be at, that should at that time be at 1:30, Ms. Thompson, because, unless Mr. Ellis is on bail, 9 a.m. If he's in jail, 1:30.
Yes, sir.
Okay. All
Yes,
right.
sir.
Anything else, Ms. Thompson?
Not anything, Your Honor.
All right. And that's your only case today. Is that correct?
It is. May I be excused?
Yes, that will conclude this case. Thank you, Mr. Ellis. We'll see you on August 4th. Thank you, Ms. Thompson.
Yes, sir.
Have a good day. All right. Is Mr. Dunn available in the jail court?
Yes, sir. We'll grab him right now.
Okay, if you'll bring up Mr. Dunn. Mr. Adams, are you ready on that? Okay. And you can stay where you are, as long as you'll just speak into the microphone. For me, what's important is that they hear you, because unfortunately, everything has to come through my computer up here, microphone wise. And you can remain seated too if you want to, Mr. Adams. The COVID has suspended rules of decorum as well. It appears.
Yeah, Mr. Head didn't wear a coat and tie this morning, so apparently those rules have been suspended.
I think he's still on YouTube, Mr. Cox. I think he's still watching. Yeah, nor did Mr. Green, but you know, I'm not keeping.
Well, Mr. Green had a bow tie on at least.
50, so he's 50% there. He's 50% there.
He's halfway there.
Mr. Adams is 100% there. Mr. High is 100% there. Ms. Melantry is 100% there. See, we need 100%ers around here. State's 100%, but I'm not keeping records. It's gonna be like prison. I'm gonna scratch it into the wall. I think Mr. Manning's 100%, if that's Mr. Manning. Oh, it is. There we go. All right, while Mr. Dunn's coming up, that's just going to be an announcement on status of CPS records. Is that right? A couple of, okay. All right, good morning, Mr. Dunn. How are you, sir?
Hi.
Okay, good. Can you hear and see me okay?
Yes, sir.
Okay, good. Can you see your attorney, Mr. Adams? See him
Yes, sir.
there, he's sitting at the table?
Yes, sir.
You see him there? Okay. All right. Court calls CR 18308 and CR 18472, State versus Calvin Leroy Dunn. And I believe we have a couple settings. One the court's aware of is a status of CPS records. And I believe that we were also set, I believe, just on an evidentiary docket. Is that correct, Mr. Adams?
That's all correct.
Go ahead, sir.
Okay, Your Honor. We got our subpoena served to the Department of Family and Protective Services.
And Mr. Adams, if you'll bring that microphone a little closer.
Sorry. We served a subpoena on the Department of Family and Protective Services a few weeks ago in an effort to obtain what I'm not exactly sure. I know that there
Because we can't hear Mr. Adams.
Yeah, if you'll just really.
All right. I know that there exists a couple of different, or at least one previous investigation by the department, that being DFPS, that involved Mr. Dunn. I don't know what those records contain. I believe it is incumbent upon me to find out if I can, if there's anything relevant or useful in those records. To that end, we served a subpoena on the department in the beginning of this month. The department has since filed a motion to quash the subpoena, or the alternative to seek an in-camera review of those records. I would join the department in requesting an in-camera records. That takes some of the burden off my shoulders. I don't have to have that. I'm certainly not joining the department in their request to cross the subpoena, but I would not oppose their request for any camera review those records. And this is in
Any of those in the motion?
180017.
What are the other issues?
That same clause number 472, there exists a forensic DNA from UNT Health Science Center. I've filed, it's my suspicion that the state will, at trial, intend to admit into evidence DNA test results. At this point, the state has not yet designated a testifying expert witness, although I anticipate that they will designate one of the two forensic experts who signed off on the report from the UNT Health Science Center, either Kendra Philippe Ortega or an analyst with the delightful name Farrah Hopper. But they haven't done that yet, so I filed a motion asking them to do so. Once that is done, I filed a motion asking for an examination hearing of their designated expert witness, because I believe that the testimony of that witness regarding how the DNA test results are arrived at may raise a suppression issue. And so to that effect, or to that end, I also have filed a motion to suppress. So, but they need to fall like dominoes. The first needs to be the motion to the identification or designation, then the examination, the dollar hearing, and then potentially the suppression.
All right, let's first on the CPS record. So my only concern about doing an in-camera inspection is that you said you didn't know what you were looking for, if anything. So I'm not sure what the court would be looking for if we're not able to, if the state and defense can't narrow the scope for the department for them to know what they're looking for, then I'm not sure just producing a bunch of records to the court that I would know what I'm looking for. So are we able to narrow that scope as to exactly if we're looking for an outcry witness on a certain date at a certain location regarding certain children?
I believe, Your Honor, that the report or any records that might be germane or relevant would involve the alleged victim, because I believe that the alleged victim and Mr. Dunn were both participants in or subjects of the same departmental investigation.
And so what does the subpoena say? How did you narrow it for the department? Does it say any and all?
Yes, sir. I'm afraid so. Give me just 1 second. It's intake reports, demographic data. It's pretty broad, you know. That's simply a function of the result of the fact that I don't know what's in the records.
But it's germane to one child, many children, one date, many dates, one location, many locations.
One child. One child. The alleged victim in this case has 2 children, one of whom is not Mr. Dunn's child. So, but again, because I don't know any particulars about the investigation, and I visited with Mr. Dunn about that, his limited knowledge is not able. I can't fill in the gaps with his assistance. So unfortunately, I'm left where I am right now.
So the CPS records that you're looking for are any that are made by the department of the child that is the alleged victim in this case?
The alleged victim and the alleged victim's child of whom Mr. Dunn is the responsible.
Your Honor,
Is it a child of a child?
The alleged victim was a minor when alleged assaults. But now reached the age of majority.
And have,
Correct.
okay, that makes sense. Ms. Curry?
That's all I would, Your Honor, is that the alleged victim is actually the mother of the children, but the mother was a minor at the time of the child's birth.
Okay. And does the state want to be heard? Does the state have a position on the DNA, on the CPS records?
Your Honor, we're not opposed to an in-camera review. I believe under the current state of the law that Mr. Adams is entitled to those records unless the court finds that there is something in there that is privileged, that is private information regarding either the mother or the child of the child.
And Mr. You said that the department has filed a motion to quash, and in the alternative is requesting a camera review.
Correct.
Okay, I haven't seen that. And so is there an order attached with that motion that the court could grant? If not, then what I would ask the state and defense to do is to fashion an order that the court could sign to direct the department to produce those records for in-camera review.
Your Honor, I do not think the department attached. I did not get a copy of a proposed order from the department. I did get a copy of the motion quash in the attached exhibits to that.
All right, there being no objection then from the state on an in-camera review, then the court will grant that. But I would ask the parties to fashion an order for the court to sign, provide that to the court, and then the court will sign and forward it back for service upon the Department of Family and Protective Services.
The department's order or motion was filed by Tree Savage in the Longview office. I'll get in touch with her and see what we can do with that.
Okay. All right. So that'll take care of the CPS. Now, in regards to, the court kind of took it as just an from Mr. Adams of what he planned to do if the state designated its expert witness regarding DNA. We're kind of speculating about what's going to be done. And so at this time, is there a request? What you're telling the court, Mr. Adams, is that you're not in a position to move forward on a motion to suppress until you know who's going to be designated. But you do already have the DNA report?
That's correct. It was provided to me.
I'm pretty sure I filed a pretrial letter.
Does the state have any position on Mr. Adams' request to set for hearing the expert opinion testimony for Mr. Adams believes that there's potential suppression attached to that and has asked to take the expert on board hire.
Judge, the first issue, and Ms. Curry is checking, I can't access the clerk's side, but I think I may have already designated the DNA analyst as expert witnesses in this case. Ms. Curry is checking on that. If I haven't, I will. Last week, I filed a written response to Mr. Adams's motion to suppress and I served that on Mr. Adams via the e-file system. The state's concern is that a motion to suppress isn't the proper avenue for what he's trying to accomplish here. I think what he's trying to accomplish would be better served in a motion in limine or a 702 Daubert hearing. It's my understanding and belief that a motion to suppress is reserved for a constitutional violation regarding a search, a seizure, or a statement. And he's trying to suppress the DNA, I would say more on prejudicial grounds than a constitutional ground. So it's the state's position that a motion to suppress isn't the proper avenue. That the proper avenue would be a 702 hearing or a motion in limine to try and keep this evidence out up until the court rules on its admissibility. There is. Okay. And Judge, Ms. Curry did find a pretrial letter that I filed designating the DNA analyst as an expert witness.
Mr. Adams.
I do not have I'm not the first lawyer to represent Mr. Dunn, so.
And Judge, what may have happened was, I believe Ms. Thompson was initially Mr. Dunn's attorney, and that may have been served on Ms. Thompson and not gotten to Mr. Adams. We'll make sure that does get to Mr. Adams.
And Mr. Adams, respond to Mr. Cox's argument that your request question the state's expert would not be, the avenue would not be a suppression hearing, but rather a 702 hearing before trial or during trial?
Well, Your Honor, I haven't seen Mr. Cox's response yet. It hasn't made its way to me through the process yet. So I don't think so. I didn't get to all my emails yesterday. In the motion to suppress I have filed, I allege constitutional grounds as the basis for this question. But again, this is all presupposing testimony from the expert witness. I have an idea as to what that expert witness is going to say with respect to the math or algorithms that go into how the test is work. If it's consistent with past DNA tests or methods that I've dealt with in the past, and I think I have an issue here. I think having a Daubert hearing would probably help me decide whether I want to stand on my motion to suppress or address it the way Mr. Cox is suggesting. I'm going to address it one way or the other, and I don't care whether it's through a motion to suppress or the appropriate way it's a motion. But I think I need to hear the testimony from the witness before I want to get the car before.
Mr. Cox.
Judge, I could barely make that out.
I think I need to have, having the Daubert is going to, I believe, help me to decide whether or not I think the appropriate vehicle to accomplish what I'm trying to accomplish is either a motion to suppress or a motion to eliminate. In the motion to suppress does allow, allege, or assert a potential violation of a client's constitutional rights if the DNA evidence is admitted. But again, I don't know that the DNA evidence would violate a client's constitutional rights until I hear the testimony, until we have the testimony of the forensic expert, the forensic analyst. I'm open to the suggestion that the appropriate vehicle here is a motion to eliminate. I'm certainly, I think it would benefit me if I see Mr. Cox's response to the motion to suppress, which again, I haven't received yet from the district clerk's office. But if it's one of those happy occasions where Mr. Cox and I agree on that, I'm happy to file something else.
At this time, only potential issue on a motion to suppress the DNA results.
Correct. And that could be used to arrive at.
Okay. All right. Then what the court's going to do then, the court's going to just carry the motion to suppress to trial, allow you to bring it up then. You filed it pre-trial 7 days prior to in accordance with the code. So we'll carry that to trial, and then perhaps we can have a pre-trial at trial on a 702 and hear it then, or carry it with a motion in limine. And then I think we'll be able to satisfy your request at that time rather than having it a pre-trial.
That's fine. Would we be able to go ahead and set the Daubert hearing today as the state designated?
No, I would anticipate that we would set it probably at the time of trial. We'd set it on a day. We'd pick the jury, and then we would pick an afternoon or a morning to hear that during trial outside the presence of the jury. Okay. Then what we'll do then is let's set this for status on the CPS in-camera review. And I'm not sure how long it will take the department. I mean, we're gonna have to get the order to the department. And I'm assuming they probably, since they filed the motion to quash, they probably already pulled the records, I'm assuming, but that is an assumption. So let's set it for August 27th. And then if Mr. Adams, if you'll speak with Ms. Savage and get the court in order, I'll sign that and then have the records produced in camera, and then I'll have those reviewed, and we'll have an announcement on the 27th if any of those records would be responsive and admissible for your purposes on the 27th.
Your Honor, one more issue on this case.
Yes, ma'am.
I believe there's a witness there at the courthouse that Mr. Adams had subpoenaed for this morning. She contacted me wanting to know where to be. I believe the court's coordinator, Ms. Barker, was helping her. But she's there in response to a subpoena that he issued on the motion to suppress.
Okay. Mr. Adams, we're not moving forward on a motion to suppress today, so is it okay to release your witness? All right, you're free to go. Thank you. Thank you, Ms. Curry. All right, if there's nothing further, then this case is set for August 27th at 9 a.m. And we'll see you then, Mr. Dunn. Any issues, Mr. Dunn? Did you hear Mr. Adams okay?
Yes, sir.
Okay, you did. All right. All right, then that'll conclude this hearing. Thank you, Mr. Dunn.
I don't have more business before the court.
Yes, sir. Thank you, Mr. Adams. Appreciate your patience.
Thank you.
Ms. Millentree, are we doing a plea on Mr. Scott?
No, I haven't moved forward right now. May it please the court.
Well, hang on. I just want to know if we're doing a plea or not.
Yeah.
Okay. All right, Mr. Hyde, we're doing a plea with your client? Yes. Is your client ready? Yes. All right, let's come on up. All right, and Mr. Hyde, if you want to, you can come up here at that microphone. Mr. Salazar can stay there. That way we can have some. All right, this is in cause number 341, State versus Michael Philip Salazar. Mr. Salazar, if you'll raise your right hand, I'm going to place you under oath. Mr. Salazar, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth? So, all right, you can put your hand down. Take just a moment and review your documents. Asked Ms. Cassell to, I believe that she was attempting to swear and she only wrote that. She only wrote that.
Yes, sir.
Yeah. The clerk to come in here and swear Mr. Salazar. Yeah, she only wrote 30. She didn't write a month or a year, and she didn't sign her name. All right, while we're waiting on that, Mr. Salazar, you are Michael Salazar, is that right? And Mr. Salazar, make sure you speak up loud enough in that microphone so that we can all hear you. And Mr. Salazar, have you had sufficient time to review the state's motion to adjudicate that they filed in your case with your attorney, Mr. Hyde? And have you had enough time to have all of your legal questions answered? Do you have any questions before we proceed? Go ahead. You've already done it? Okay. All right, Mr. Salazar, here before the court on May 31st of 2018. You pled guilty to the offense of assault of a family or household member with a previous conviction, a third-degree felony offense. After hearing the evidence, the court found that there was sufficient evidence to convict you of the crime. However, the court deferred a finding of guilt in your case and placed you on community supervision for a period of 5 years. It was during that period that the state filed a motion to adjudicate your guilt and requested the court to revoke your community supervision. Have you had an opportunity to review the state's motion to adjudicate with your counsel, Mr. Hyde? And Mr. Hyde, does your client waive the formal reading of the state's motion to adjudicate? All right, and he's going to enter a plea of true to all counts as alleged? All right, Mr. Salazar, as to counts 1, 2, 3, 4, 5, 6, 7, 8, and 9. Are those counts true or not true?
Judge, I'm sorry. I'm going to need to interrupt you real quick. The paperwork was prepared for the state abandoning count 1 and for him to plead true to counts 2 through, I believe it's 8.
Okay. Then Mr. Salazar, as to counts 2 through 8, counts 2 through 8, are those counts true or not true? And Mr. Salazar, are you telling me that those counts are true because in fact they are true and for no other reason? Has anyone threatened you, forced you, or otherwise pressured you to plead true to any of these counts? And it's my understanding that the plea agreement in this case is that the state is abandoning count 1, and upon your plea of true to counts 2 through 8, that they're recommending that your guilt be adjudicated. That means that you become convicted of the offense of assault of a family or household member with previous conviction, a third-degree felony, that your punishment be assessed at 10 years confinement in the Texas Department of Criminal Justice Institutional Division, but that sentence be suspended and you being placed on community supervision for a period of 4 years, and you being ordered to pay the balance of your financial obligations that were previously imposed upon you, including fines, court costs, and any other fees. Is that your understanding of the plea agreement, Mr. Salazar? Yours as well, Mr. Hyde? All right, then the court will accept Mr. Salazar's plea of true to counts 2 through 8. Court hereby finds each count to be true. Court hereby follows the plea agreement in this case. The court, having found counts 2 through 8 to be true, convicts Mr. Salazar of the third-degree felony offense of assault of a family or household member. The state assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice. The court will find that it's in the best interest of the defendant and the community for that sentence to be suspended and Mr. Salazar to be placed on community supervision for a period of 4 years. Court also orders Mr. Salazar to pay the balance of his financial obligations as previously ordered. So it seems to me, Mr. Salazar, that this is your second bite at the apple. Is that right? So you were already given an opportunity to be on probation and successfully comply, yet you did not do that, right? So what makes me think that this time is going to be any different for you? Are we just delaying the inevitable of you violating and coming back before the court and being sentenced to 10 years in prison? What's different this time? Did you have 2 kids? Did you have any of your kids during any of the periods of your violations? You did. So that tells me that you weren't thinking about your kids then. Well, I've already told you to follow the plea agreement, but I'm telling you that there's not going to be a third bite at the apple. Does that make sense? You come back before me on a motion to revoke your community supervision. You just better get your attorney to get with the state and figure out the best sentence that you can get. All right. So it better be an eye opener. I hope it's an eye opener. I hope the next time I see you, it's on a successful completion and I'm ending your probation early because you've been a model probationer. Because if it's not, then your children are going to be visiting you in prison. Understand? All right, Mr. Salazar, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out terms and conditions of the sentence. I'm going to have you step up here to be fingerprinted with my bailiff. Anything further, Mr. High? Yes, sir.
The coach sent me something today about a client we have set for the indicating I sent a letter of recommend back in February and I had one court appearance via video and we sent it to that day. Apparently there were 2 cases in my office as the case number on the other.
Who represents Mr. Martinez? You do.
I wasn't aware that there was 2 cases in the same transaction, the drug case and the gun case. I sent a letter of rep.
On one.
One of my office people missed it, but I'm not aware of anybody missing in jail. I can't just on the court session, nobody else showed up for this.
Were they same training?
Yeah. And I didn't even know there was somebody else. Or yes, they never had contact.
But you believe them to be by someone else on the other charge?
That's just what they told me. They said he needed to pay his court-appointed attorney's fees, and I don't know who that would be because I'm not aware of anybody that was talking to him. They sure didn't come to court with it. We had court on this time. We set it for next week. Send a letter. Just send another letter of rep on that other cause number. But if there's somebody else on it, motion substitute, I just don't know who that would be. Most of the time, yes, mid part of March. And I've been negotiating with Ms. Curry on the case, and nothing's been brought up about anybody else. We've been discussing both cases. I just wasn't aware of it. Just that he worked on both.
It appears on PR 19-181, Miss Ann Thompson represented him, and she has submitted an invoice bill of $469.80, and that's a charge of that's the unlawful possession of firearm by a felon. And so she was court appointed to represent him. And I'm going to tell you when. I'm gonna share my screen with you
Probably.
right here. All right, so on August 28th, he applied and Ms. Thompson was appointed to represent him on this. That was indicted. That was the possession of firearm. And this was the PCS, probably without a lab at that time. So he had requested court-appointed attorney and she was appointed. And let me show you another. So, yeah, and so we didn't have a motion to sub on this case. We had heard about it because Ms. Thompson had emailed Ms. Tabraham. And so we told her that before you subbed in, I was going to require him to pay whatever he owes, whatever she was going to bill. This is what she had submitted. And obviously the court has not signed it yet, but here's the billing statement that she submitted. And this is on file with the clerk. And so here's an email from Ms. Thompson to Mr. Cox where they're discussing, you're substituting in. And so we asked her to submit whatever she was going to submit. So yeah, before I would grant your motion to sub in, he would need to pay this right here, $469.80. So he can pay that to the clerk, or really the best place to pay it would be the probation department. So they can give him credit. So when is this, when did you say it was? Court setting format, let's see. Seven for pretrial. So yeah, so if you want to do a Zoom on motion to sub, if we can have that paid, then I can take that up on 7/7 if you want to do that. Yes, sir. How are we on Mr. Palmer? We still waiting? You find out. Just find out for me. That way, if he is, we can get him going. Did we do a reset notice for Mr. Palmer? It's right here. Is this it? Okay. Negative? All right. All right. We take this to Mr. Palmer. Mr. Palmer, if you'll just come down here. I'll have you sign this notice. Mr. Cox, Mr. Palmer was a negative on his UA, so I'm gonna have him sign his reset notice for August 27th, and we're gonna let him go. If you'll let Mr. Will you let Mr. Green know for me?
Sorry?
Will you let Mr. Green know?
I will.
All right, thank you. All right, you're free to go. Okay, all right. All right, Mr. White, are you ready?
Yes, sir, I am.
All right, court 2019-512, State of Texas versus Timothy Lee James Jr. All right, and Mr. James is present in the courtroom. Mr. James, if you will, raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, nothing but the truth, so help you God? All right, and just make sure you speak up. And is that microphone on green? Okay, just make sure you speak up. Mr. White, do you want the state to sign their certificate of appeal about what they've provided to you?
No, sir.
You don't care if they sign that?
No.
Mr. Cox, Heisel, I don't have the state's signature on any of the plea paper. I don't have it on the written admonishments or the state certificate of appeal.
Judge, that was Mr. Woodwhite's case. I will make sure Mr. Woodwhite gets over there at some point today to get you a signature.
But he has reviewed it.
Yes, Your Honor. Well, let me say that. Let me make sure, but I believe so. They were working on it yesterday afternoon.
And Mr. White, we're waiting on Mr. Woodwhite. Mr. James he has served 4 days in jail already.
Yes, sir. 4 days credit, $2,500 fine. And as per his, probation, pretrial release conditions, Your Honor, he, had an ignition interlock, and I will say his probation department provided an order, but if the court doesn't get an order, I'll be back.
Okay. Mr. Woodwhite, I noticed that the written plea admonishments, certificate of appeal of State versus Timothy James Jr. were not signed. Have you gone over this paperwork? And
yes, Judge, I have. It's my belief that my legal assistant emailed them to myself and Mr. White. I did not being in your court very often, I did not understand the procedure, so I didn't have a chance to sign them. I have reviewed them. They do appear to be true and correct. As far as, I'm assuming Mr. White hasn't altered those in any way. No indication that he has. But I've reviewed the paperwork that was given to Mr. White.
yeah, it would be for sorry, there's a little people there. Class, actually a change of charge to a deadly conduct. Class A misdemeanor, 4 days in jail, 4 days credit, $2,500 fine, $60 restitution, $270 court cost, $15 reimbursement fee, credit for time served.
Yes, Judge, that is our agreement. Yeah, Judge, and I'd be happy to come and sign that paperwork at some point later in the day.
Okay. Was it filed in as a DWI and then going to be changed to a deadly conduct, or was it filed in as a deadly conduct?
It was filed in as a DWI second.
Okay. All right. They can just, at some point you can come by the clerk's office and sign this, so we'll have it complete.
Yes, Judge, I will.
All right. Mr. James, have I placed you under oath?
Yes, sir.
I did. Okay. Thank you, sir. All right. You are Timothy Lee James Jr., correct?
Yes, sir.
And you are represented by your attorney, Mr. Nolan White. Do you feel like you've had sufficient time to review your case with Mr. White and have all of your legal questions answered? Mr. White, do you believe Mr. James to be competent today?
I do, Your Honor.
And Mr. James, you ever been diagnosed with any type of mental condition?
No, sir.
You are a United States citizen, and you do read, write, speak English. And you've understood everything that you have read, reviewed, and signed here in court today. Is that right?
Yes, sir.
All right. And you've heard Mr. White announce to the court, and you've heard the court repeat what the plea agreement is in this case. And is that your understanding of the plea agreement?
Yes, sir.
And that's what you're wanting the court to proceed with today and approve. Is that correct? All right, Mr. James, the offense of daily conduct is a Class A misdemeanor. It does carry a range of punishment of confinement up to 365 days in the Van Zandt County Jail and a fine not to exceed $4,000. Any punishment assessed in accordance with that would have to fall within that range. And according to the plea agreement in this case, a 4-day sentence and a $2,500 fine would fall within that range of punishment. Do you understand that?
Yes.
Mr. James, to the charge of deadly conduct, how do you plead? Guilty or not guilty?
Guilty.
And Mr. James, are you pleading guilty because in fact you are guilty and for no other reason?
Yes, I am.
Okay. And no one's threatened you, forced you, or made you plead guilty to something you're not guilty of? All right, then the court will accept Mr. James' plea of guilt. Mr. White, is there any objection to the offer of State's Exhibit 1, the stipulation of evidence in this cause?
No, sir, we have no objection. We also, I know that there was discussion as whether or not the state had signed those documents. We've gone over via email. The state wants to come over and sign them. Subsequent to this, that's fine.
Okay. All right, there being no objection, the court admits State's Exhibit 1, stipulation of evidence, and takes judicial notice of Mr. James' judicial confession. Anything further from state?
At this time, Your Honor.
Anything further from the defense?
The only thing further, Judge, as part of the pretrial release conditions, Mr. James had a mission interlock on his vehicle for some now, 2 years. I spoke to probation. They're going to get an order to have that removed. They have it. State doesn't have objection.
Any objection? Did you hear Mr. White?
He was cutting a little in and out. It's my understanding that he's asking to have the interlock removed based on probation's recommendations. They would have no objection if probation so recommends.
Well, and Mr. James on probation?
This is part of the pretrial release condition. And it's also not.
There's no case. Yeah, there's no case, Judge. State has no objection.
Okay. All right. All right, and this judgment for Judge Winters, and I'm gonna mark through his name and insert my name. All right, Mr. James, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of your sentence. I'm gonna have you come forward and be fingerprinted with my bailiff. Go. Sorry, did you do that? Sorry, I didn't even realize that. Didn't realize, I'm sorry. Making you do double work. You were already ahead of the game. Way ahead of me on that. Yeah, it doesn't matter. It doesn't matter. Yeah, that's fine. If you'll make sure that this gets sent to Mr. Schmidt and Mr. Cox. Thank you. Did you have something for me? Since it's all one. I'll sign it. I'll sign it. All right. Thank you.
You're welcome, Joe.
That's all you, hang on, what do you mean that's all you have? Hang on, I'll let you know if that's all you have, hang on. I think that's all you have.
Yeah, if you want to start with the proceedings after that.
You're all for that?
I will vacation.
All right, thanks. All right, let's see here. Is Miss Smith here? You're Miss Smith? Come on up, Miss Smith, right here at the podium. All right, you are Lucretia Chantel Smith, is that right? Ms. Smith, I have before me a document that is an amendment to the conditions of your community supervision. And it says that your community supervision is to be modified by extending the period of supervision for a period of 2 years, which would extend your community supervision until September 9th of this year. I'm sorry, 2 months. You didn't say anything. I said 2 years. You didn't say nothing. 2 months. You were gonna say, hold up, Judge. That's not right. It's 2 months. All right. So 2 months until September 9th of 2020, and that your probation fees would be waived during that time, and that your analysis fee would be waived. Why are we extending you for 2 months?
I didn't pay. I had $120 that I needed to pay. I paid it this morning. And I had to give her my community service hours. I couldn't find my paper, so I had to go back and get them signed again.
Okay. All right.
I think I gave a copy to the probation office this morning.
Okay.
So I paid $120 and this morning.
Is that gonna complete you altogether?
Yes, sir.
Is there anything else that you lack on probation?
No.
Do you want to, rather than me extend you for 2 more months, let me check with probation to see. There's a chance that maybe we could discharge you this morning rather than have you extended. So I'll tell you what, just have a seat for a moment. I'm going to take up a case with Miss Melantree here. And if you have paid and you've turned in everything and they say that they are satisfied, then you could just walk out of here and be done today and not have to worry about reporting and doing those things for a couple of extra months. So, yeah, so you're welcome. Go ahead and have a seat and bear with us just a moment. Now, if probation comes back and they say, no, we want her to be extended, then we'll continue our conversation, okay? All right, just have a seat for me. All right, Ms. Melantree. All right, so what's going on with Mr. Scott? Not here today?
He's not here today. On Friday, I received a text from him stating that he was in the hospital. He was in the hospital for 2 weeks due to some type of infection. When I was going back and forth, I said I need a letter from the doctor stating that. They started going back and forth with me as far as you call the hospital. I know I can't get the information unless he's while we were doing a plea, he picked up the phone and called me. I called him back, and he got released on Friday. So I told him he had an opportunity to be here, but with this some type of blood infection, he can't go out because of COVID. He can catch and die, catch disease and die. So when I'm asking the board to at least extend it for 30 days, because we do have a plea offering this matter. I do have pictures of him all hooked up on IVs, but at the same time, I think it's more effective when you have a letter to get to the court. I told him that as well as I was speaking with him, that if he will call his doctor and have his doctor send me a letter that I was to. I asked him whether anybody asked me whether Monday his mother was dealing with me. He found out on the phone to his mother, she lives with his doctor tomorrow at 1:30. When she leaves, she's also giving me that doctor's number. So at 1:30 tomorrow, I will get in contact with, tell the doctor the purpose of the letter to show the court that Mr. Scott, I'm not repeating him being sick, but it just helps to confirm this is what he has, the rare what he has. And with COVID, we don't want someone to come out and be exposed because his level is so low that he ends up dying. So I just asked the court to give him these 30 days that he knows he has to be here because it's going to be an awful time served.
Does Mr. Scott ever contact you when these things happen, or are you always having to contact him?
He contacted me
When did he contact you?
on Friday, but he contacted me by text message and showing me pictures. And I kept on saying, pick up your phone, I need to talk to you. And when he first showed me a picture of him being drugged and everything, I just said, what is wrong with you? I didn't want to assume it was COVID. I tell me what's wrong with you. And no response. Then on Monday, I received something, but I received it after hours when I was asking, give me something so I can get it to the court. I don't know his family, they don't know the seriousness of this. And what y'all said, this is very serious. And I told him today, I may have been cruel, he may have thought I was cruel. I said, a lot of people come up in wheelchairs without these all the things. You have to communicate with me, not for me to communicate with you. So he called me on Friday and I kept asking myself, and then sending me stuff on Monday. If you want to talk to him, I can text him and he can give me a Zoom number for him to hear from the court, but this is our second time here.
Yeah, I think he heard from me last time. And I think I was pretty clear on what was happening if he wasn't here. What I will do for you, Ms. Mellentree, I'll do it for you. I'm not doing it for Mr. Scott. This is what I'll do. I will issue a NISI bond forfeiture today, NISI alias Capias, and I'm going to give him 48 hours to provide you with the proof that he's been in the hospital and that there's a medical reason he can't or shouldn't be here today. Absent that, if I don't have that within 48 hours, then the warrant's going to go active. Okay. State, do you care to be heard on this at all?
Your Honor, I think you pretty much covered it.
Okay. All right. Thank you, Ms. Mellentree. Yes.
You all have a happy 4th of July.
Thank you. You too. Be careful.
Thank you. Be safe. Thank you.
Sorry, I thought it was a sign there, so I had to put my name twice. And Stephanie, on Miss Smith, right? Because she said that she's paid everything and turned in all of her hours. So we're just checking on her to see if we even need to extend.
So all two stuff is there's a transparency from $15 to Elizabeth's office. This is on here and was trying to call payments and straighten up. That she did go into the publishing, that she did a meeting service. She said about $15 that was supposed to be to commercial work. And sorry, I didn't understand all of this. I'm with the company.
Yeah, so I mean, I can set it. I mean, we can set it next week. We set it next week, the 9th. We can set it on the 23rd.
And then it gives him time to figure out $15, because if that's good, this goes away.
Goes away, and then she just discharges. Naturally. Okay. All right, Ms. Smith. Mr. Manning, I'll be with you in just a second, sir.
Yes, Judge.
All right, Ms. Smith. The probation department has confirmed for me that your probation hours are complete, that you have paid what you owe the probation department. They say that there is, in the financial records, there's a small discrepancy between the two offices regarding $15 payable to the clerk here towards fines and stuff. They're trying to straighten that out, and it may be an issue with systems. So what I want to do is, rather than amending you and extending your probation today, and rather than just discharging you today, what I would like to do is reset this for next Tuesday. And we can even set you to where you could appear on your phone, like you see others doing here. And I'll let you talk to probation department on that. If you want to do that, we can set you up to appear by your phone. There's a good chance that if they can figure out the financial $15 issue, that once they get that solved, that then you wouldn't be extended and you could just have your probation expire like it's scheduled to. Okay? So if you have no problem with that, I've got no problem with that. And I think that's what we should do. And then if they get that thing figured out, they may even call you and tell you, you don't have to appear by Zoom. You don't have to appear on phone in court. Okay? All right. So let's, so I'm not gonna sign anything. I'm gonna take this and tear this up, and then just talk with probation department, and they'll help get you straightened out on whether I told Ms. Buren that we could do next Tuesday, or we could do next Thursday. It's before she expires. They may already have it though. They may just let them work. Save your $15 right now. Let them figure it out, because I don't think it might not be a payment issue. It might be a who took it and put it where issue. Okay. Let them work on it, look at it, and then if that's the case, your probation department can tell you later. Okay, so you're good to go for me, and probation department will tell you when you need to be here next. Okay. All right, you're welcome. Well, yeah. Yeah, I wouldn't take off work. We may have done today. If you don't take off work, you could always do it 5 minutes on your phone in the parking lot or something. Okay? All right, yeah. Just go and have a seat and they'll be with you. All right, Mr. Manning, are you ready on your writ on Miss Odom?
Yes, Judge.
All right, State, are you ready?
We are, Your Honor.
Okay, all right. Where is Miss Odom? Is she in the courtroom?
Right now as we speak.
Okay.
And Judge, would you be able to hear us if we sat at the table?
Go sit down and let's find out.
How's that?
You're fine. It's going to be her that I'm more concerned with.
Yes, sir.
So I think that'll work as long as she speaks up or moves the chair. You can move the podium out of the way, and if y'all need to maintain distancing, maybe you sit at the, either move that or you can move it. You can sit at the desk, one of the two. I'm gonna take just a moment and I'm gonna pull your writ up. All right, this is in writ number WR 20-37, Courtney Odom versus the state of Texas. And Ms. Odom's bail is set currently at $500,000. I see in the writ that the request is that the bail be reduced to a $50,000 personal bond. Is that correct, Mr. Manning?
That's correct, Judge.
And that in the writ, it says that the petitioner may be able to raise $1,500 for a professional bondsman. Is that correct?
That's correct, Judge. Based on our last conversation, she said she might be able to get that amount with the help of family, but she doesn't have that amount on her own.
Okay, all right. Are you going to call your client to testify?
Yes, Judge.
All right, and Ms. Odom, if you will, raise your right hand for me. Ms. Odom, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, and Ms. Odom, you're a little bit away from the, put your hand down. You're a little bit further away from the microphone in that room. So I'm going to need you to speak up loudly and clearly so that my court reporter who's present in my courtroom can hear you, okay?
Yes, sir, Your Honor.
All right, and you're going to have to be louder than that.
Yes, sir, Your Honor.
That's it. That's better. So whenever Mr. Manning is asking you questions and you're giving answers, you're sitting in a room, and I know that you can hear each other, but it's very important that I hear you, that the court reporter hears you, and that the state can hear you, okay?
Yes, sir, Your Honor.
All right, thank you. All right, go ahead, Mr. Manning.
Judge, before we begin, I asked the court to take judicial notice of the court's file, specifically the application of indigency that was filed by my client leading to my appointment.
All right, any objection from the state?
No objection, Your Honor.
All right, court will take judicial notice of the application for the appointment of counsel. Go ahead, Mr. Manning. Go ahead.
Ms. Odom, when were you arrested on this offense?
Thursday, May 14th.
Okay. And what offense were you arrested for?
Kidnapping.
All right, so Mr. Manning, I'm just gonna ask you to have Miss Odom move her chair closer to the camera because I can't hear her. And I know Miss Grisham's gonna have a hard time. Maybe just drag her chair as close as you can. She's rather soft spoken, and then you can stay. I know you may need the table, Mr. You can stay there, and Miss Odom, if you want to, you can kind of turn a little bit. Just make sure you're speaking towards the microphone, okay?
Okay.
All right, thank you. That'd be better. I'm sorry, Mr. Manning. Go ahead.
That's fine, Judge. Are you able to afford a $500,000 bond?
No, sir.
Okay. And based on our conversations, was the best you could come up with you and your family and your friends help $1,500?
Yes, sir.
Okay. Let's talk a little bit about your job history. Where have you worked?
Suddenly.
Okay. And if you'll face the camera, how long did you work at Suddenly?
I worked at Suddenly for 3 months.
Okay. Prior to that, where did you work?
Target.
Okay. What did you do at Target?
I drove forklift.
Okay. And how long did you work there?
4 months.
Prior to that, where did you work?
I worked at the Baylor Hospital in Dallas.
Okay. And how long did you work there?
About 5 months.
And what were you doing there at Baylor Hospital?
I was in nutrition service.
Okay. Does that basically conclude your work history?
Yes, sir.
Okay. When did you graduate high school?
2018.
Okay. And where do you live?
Tyler, Texas.
Who do you live with?
I live with my mother.
Anybody else live there?
My brothers.
Okay. How many brothers do you have?
I have 4 brothers total.
Okay.
But I live with 2 of them.
If you were released on a PR bond, where would you be living?
With my mother.
Okay. And she has sufficient means to care for you there at her house?
Yes, sir.
Okay. Who else is living there with your mom and your brothers?
My son as well.
Okay. How old is your son?
He is almost 3 months.
Okay. Do you go to church or involve any of the activities over there in Tyler?
I was involved at Noonday Baptist Church, but I stopped going due to the fact that I was pregnant.
How long have you lived in East Texas?
I lived in East Texas my whole life.
Okay. And do you have any prior criminal history?
No, sir.
Let's talk about assets? Do you have any real property?
Just my vehicle.
And is your vehicle in your possession or in the possession of anyone that you know at this time?
No, sir.
To the best of your knowledge, where is your vehicle?
Last place I heard it was at the police station in Elizabethtown.
Do you have a bank account?
I do have a bank account.
Okay, and at last check, how much money was in that bank account?
Less than 300.
When you were living with your mom, did you have any rent or utility responsibilities?
Yes, sir.
And did that come out of your earnings from working at Sutton?
Yes, sir.
Your Honor, at this time I pass the witness.
State.
Thank you, Your Honor. Ms. Odom, you had $3,000 in your possession that you left in your grandmother's car when you were arrested. Is that correct?
Yes, sir.
Where did that come from? That's okay. Where did that come from?
That came from Austin.
Is that Austin Walker?
Yes, ma'am.
Where did he get it?
Got it from his sister.
I'm sorry?
He got it from his sister.
From his sister. What's her name?
Willow.
That's his sister, huh?
That's what he told me.
Your Honor, just telling you that this goes outside the scope of this hearing is also irrelevant to the purposes of the bond, setting bond in this case.
Your Honor, I think that the source of the money she had in her possession at the time of her arrest is relevant to her ability to make bond. That's as far as I was going with that line of questioning, Judge.
All right, court will overrule the objection and ask the state to proceed with the financial evidence.
Thank you, Your Honor. Ma'am, you gave us a job history. It appears that the longest you've ever held a job, unless I missed something there, was 5 months. Is that correct?
Your Honor, I worked at Walmart for a year and 3 months before the hospital.
Okay. So when Mr. Manning asked you if that summed up your work history, it really didn't, because there was a year and 3 months left out.
Yes, ma'am. I apologize.
Where did you graduate from high school?
Premier High School in Tyler.
Is that a charter school?
Yes, ma'am.
And I'm sorry, ma'am, I couldn't hear a minute ago when you answered this question. I know it's already been asked, but how old is your son?
3 months.
3 months. And who has custody of him now?
My mother.
Now, your son, you were arrested originally on this 3rd-degree felony in Missouri, is that right?
Yes, ma'am.
And your son was with you at the time of that arrest, correct?
Yes, ma'am.
In fact, your son had been with you the whole time from when you left Texas, Louisiana, Kentucky, and then to Missouri, correct?
I'm sorry, Mr. Manning, I couldn't hear that.
Objection, Your Honor, relevance.
Your Honor, I think thank you, Judge. Your son was with you during that whole trip, is that correct?
Yes, ma'am.
So in the house where you live, by the way, that's the same house you were living in when this offense occurred, is that correct?
Yes, ma'am.
So you were living with your mother and your 2 brothers and your son at that time?
Yes, ma'am.
And where is your mother employed?
Target warehouse.
How about your brothers that live with you? Where are they employed?
My brother, Justin, he's too young to work. And then Corey, I don't know.
Is he employed?
I don't think he is at the moment.
How long has your mom worked at the Target warehouse?
3 or 4 years.
Was your car paid for?
No, ma'am.
What year was it?
2012.
2012?
Yes, ma'am.
What model?
Toyota.
Toyota?
Yes, ma'am.
Was it like a Corolla or Camry? I think it was a Camry. Yes. And how much did you owe on it?
21,000.
When did you buy it?
2018.
What bondsman have you talked to about making this bond?
My mom talked to some bondsman, but that's about it.
So you haven't
Miss
called
Odom.
any bond?
Hey, Miss Odom, can you repeat that? We had a little bit of feedback here. Can you repeat that?
My mom called a bail bond.
Okay.
And what information did they give her with regard to making your bond?
They said that the lowest that they'll go is 25,000.
So for $25,000, they would make a $500,000 bond.
Yes.
Do you know which bondsman that was?
I do not know.
Did you ask anyone how much bond they would make for $1,500?
I haven't asked the bail bond.
And you agree with me that when you were arrested for this offense, you were not in the state of Texas?
I do agree with you.
And your father lives in Kentucky, is that correct?
Yes, ma'am.
But he used to live here in East Texas, right?
Yes, ma'am.
And when did he move to Kentucky?
I can't remember.
Within the last year or longer than that?
It's been longer than that.
And when he lived in East Texas, where did he live?
I don't know, because I didn't visit him because I was in school, so I didn't visit him.
Do you know what town he lived in?
He lived in Tyler.
But you don't know when he moved to Kentucky?
I do not remember the exact date.
Was it before you graduated from high school or after?
It is somewhat objective. I don't see the relevance in this line of questioning.
I think her family ties are very relevant, Judge.
Judge,
Go ahead.
the history of where her father lived in the timeline doesn't establish one or the other of her family ties. She said that she's lived here all her life. She said that she lived with her mother there in Tyler with her brothers. We've established family ties. I don't understand what her father's moving habits have to do with any of that.
I'll sustain the objection.
We'll pass the witness, Your Honor.
Mr. Manning,
No further question.
any other evidence, Mr. Manning?
No, none from the defense.
All right, no more witnesses?
No, Judge.
State?
Yes, Your Honor, we call Bob Keltner. I think he's in the waiting room, Judge.
All right, Investigator Keltner, can you see and hear the court?
I can.
All right. Can you see and hear the state and see and hear the defense and the defendant?
I only see you at this point.
All right. If you're on your phone, you may have to slide over left, swipe left or right.
Okay. Yes. Okay. Yeah, I see. Yes, I can do. I understand now.
Okay. All right. You're being called as a witness to testify in the writ of habeas corpus filed by Mr. Manning on behalf of Ms. Courtney Odom. I'm going to ask at this time that you raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Go ahead, Ms. Curry.
Thank you, Your Honor. Sir, would you state your name for the record?
I'm Sergeant Investigator Bob Kelton with the Van Zandt County Sheriff's Office.
And are you a certified peace officer?
I am.
And how long have you been with the sheriff's office?
Almost 3 years.
And how many total years of law enforcement experience do you have?
In excess of 25.
You are normally a property crimes investigator, is that correct?
That is correct.
On occasion, as a part of your duties, have you been asked to become involved in crimes against persons due to manpower shortages, illnesses of the regular crimes against persons investigators?
That's correct.
And because of one of those situations in May of this year, were you asked to be the lead investigator on a kidnapping case?
I'm assisting the lead investigator.
Okay. So who is the lead investigator?
Technically, it's Will Jones, who's assigned to cases.
And Will Jones was in the waiting room this morning, but got called away. Is that correct?
That is my understanding.
And from the very beginning of this case, have you been involved in everything that Will Jones has been involved in?
That is correct.
Now, the victim in the case that we're talking about is Willow Sermons. Is that correct?
Yes, it is.
And can you describe Willow for us?
Willow Sermons is a 14-year-old female who experiences dwarfism and is also intellectually disabled.
And where does Willow live?
In Grand Saline, or in the county with a Grand Saline address.
And on May 11th of this year, on May 12th of this year, was Willow Sermons reported missing by her parents?
That is correct.
And as a result of that report, can you tell us what all law enforcement agencies became involved in the investigation to try to locate and bring home Willow Sermons?
Immediately, the Van Zandt County Sheriff's Office received the report of missing person, reference to Willow Sermons. Following that, DPS, Grand Saline Police Department, on the 12th, assisted in attempting to physically locate Willow Sermons in the Grand Saline area. Being unsuccessful the following day, the Sheriff's Office reached out to the FBI and DPS CID, who all became involved in the investigation along with the Sheriff's Office.
Would it be fair to characterize the investigation or the effort to bring Willow home as about 40 officers crammed into the Sheriff's Office, working literally around the clock, with a trailer outside that they could go sleep in for an hour or two if they needed it, doing everything they knew to find her?
Absolutely. In fact, the number you mentioned as 40 is actually a low number. It was in excess of 50 officers on Thursday the 14th, just in Texas, with another nearly 40 FBI agents spread out from Missouri through Kentucky.
And ultimately, were you able to determine whose custody or who had custody and control of Willow?
Yes, we did.
And who did you identify as that?
Austin Walker, white male who is in custody of the U.S. Marshal Service. He has been returned to Texas, but he's under quarantine, and Courtney Michelle Odom.
And did your investigation reveal whose vehicle, well, what state, let me back up, what state was Willow ultimately located in?
Kentucky.
And did your investigation reveal whose vehicle was used to transport Willow from Grand Saline to Kentucky?
Courtney Odom.
And who was in that vehicle besides Willow?
Courtney Odom and Austin Walker, along with Courtney Odom's infant son.
And I want to, for the purposes of this bail hearing, Sergeant, we don't need to go through all of the details, but I want to ask a few specific questions because the issue the judge has to consider, one of them is flight risk, and then the other is ability to make a bond. So I want to ask a few specific questions that I believe deal with her flight risk. I know we're skipping a lot of the details, but I don't think we need to go into all of those for this hearing, okay?
Okay.
Did your investigation reveal that there was an instance where Courtney Odom gave a false name for Willow Sermons before the group even left East Texas?
That is correct.
And to whom did she give that false name?
Her own brother. Courtney Odom's brother.
And did your investigation also reveal that when they left East Texas, went to Louisiana, that at that point, Courtney Odom knew exactly who Willow was, and again indicated that she needed to take steps to conceal their activities?
That is correct.
Did she have conversation with a friend of hers in Louisiana that indicated that?
As to whether or not she was in where she was when she had the first conversation with her biological father, Kenneth Odom, I'm not sure exactly where that was.
Before that conversation, was there a conversation through Facebook with a friend of hers where she indicated that she knew she was in trouble?
Yes, well, before that, I don't know. She did have several conversations with people through Facebook Messenger where she acknowledged that she was in trouble and something bad had happened.
And then at one point, did she start a conversation with her grandmother and her grandmother's sister?
That is correct.
And during those conversations, did she indicate that she knew what was going on and knew that she was in trouble?
Yes.
And in fact, did she tell her grandmother that she didn't want her son to be involved when this came to an end?
The specific language, I'm not, I don't have an instant awareness of the specific language that she used, but that is a good summary of what occurred.
Okay. She told her grandmother she needed her son. She needed her grandmother to get her son so that he wouldn't be there when she was arrested. Is that correct?
Well, it's my understanding that that the intent was that she did not want her son to be in CPS custody in Kentucky. She wanted her son to be back in Texas with family, and that was what her effort was to when she was arrested back in Missouri, and making contact with her grandmother was to get the child back to Texas.
And at some point along the way, is it correct that she also called her father, Kenneth Odom, and told her father what was going on, that she and Mr. Walker had custody of a juvenile?
Yes, that's correct. She, on the night of the 12th, there was at least one, sounds like two, according to Mr. Odom, Kenneth Odom, there were 2 conversations between Courtney Odom and Kenneth Odom where the description of what had occurred was discussed. And so Kenneth Odom was aware that Courtney Odom and Austin Walker were in custody of a minor child.
And with all of that knowledge, they kept traveling to different states. Is that correct?
That is correct.
Now, when this started, was there anything missing from Willow Sermon's home?
There was.
What was that?
It was cash, U.S. currency that was missing from the Sermon's safe located inside the residence.
And after the actors in this case were arrested, was it discovered who in fact had that cash?
There were 2 separate amounts that were discovered. Willow Sermon's retained approximately $1,700, and Courtney Odom was in possession of approximately $3,000 in U.S. $100 bills.
While the group was driving, were they ever encountered by law enforcement?
They were on the night of May the 12th in Tennessee.
Was that just a random traffic stop?
It was.
Anybody say to that officer, you know what? I need to call this to an end. I need to tell you what's going on here.
No, there was no indication that the officer was ever aware that there was a kidnapping in progress.
Was it after that Courtney Odom called her father and told her father that she was headed his way?
Your Honor, at this time, I'm going to object. This goes to neither her flight risk nor does it go to the excessive amount of bail in this case. So it's not relevant for this hearing. All she's doing at this time is showing up evidence about the offense.
Repeat that last part. There was some interference.
Judge, I would object to relevance. As I said before, it doesn't go to any of the prongs for the discussion on bail being oppressive or excessive in this case. So for that reason, it's objectionable and irrelevant to this hearing.
I'm gonna overrule because I believe it goes to the grounds of whether or not she would be a flight risk if released on a bail which could be lowered by the court. So I'm gonna overrule at this time. Go ahead, Investigator Keltner, if you can answer the question.
Okay, will you repeat the question, please?
Sure. Was it after that traffic stop that Courtney Odom called her father and told her father what she was involved in?
That is correct.
Somewhere along the way, was an effort made to conceal Willow's presence further by destroying her cell phone so that it couldn't be traced?
There were at least 5 cell phones destroyed during the course of their flight.
And were there conversations that indicate that that was done so that the phones could not be traced by law enforcement?
That is correct.
I'll pass the witness, Judge.
Mr. Manning, any questions for Investigator Keltner?
Yes, Judge, briefly.
Go ahead.
Investigator Keltner, you said that Willow Sermons is intellectually disabled. Where did you receive that information from?
That information came through the family that reported her mother.
Okay. And do you know if that's been a diagnosis or is that a self-diagnosis on their family's behalf?
Well, it's my understanding that it's professional diagnosis.
Okay. Is there any evidence of acquiescence on the part of the victim to go on this journey with Austin Walker?
I didn't understand the first part of the question. Can you say that again?
Was there any evidence of acquiescence on the part of the victim, Willow Sermons, to go on this trip with Austin Walker?
Can you use a different word besides acquiesce? I'm not sure what the definition is.
Yes, I apologize. Is there any evidence that Willow Sermon agreed or consented to go on this trip with Austin Walker?
Post-rescue, Willow Sermons indicated that she thought that they were going to Louisiana for a couple of days and that they would be returning home soon thereafter. Willow Sermons did exit the home voluntarily after being lured away by Austin Walker.
Is there any evidence that Courtney Odom participated in luring away Willow Sermons from her home?
There's no indication that she lured her out of the house, but she certainly continued with the offense. I mean, not only smuggling of a person, but aggravated kidnapping. She had every opportunity to hold her hand up. She had every opportunity to dial 911. She had every opportunity to weigh other people down.
Investigator Kelton, I understand you had that belief, but what we're here to talk about is the facts that can be proven. And so one point that you seem to bring up through the line of questioning was the evidence of my client's knowledge of when Willow Sermons was no longer Austin Walker's sister and when she became someone who needed to, in fact, be turned over to law enforcement. You said at first that you were not sure when that timeline happened based on the evidence. Would you say that that happened when she talked to her father after the stop in Tennessee or when they arrived in Kentucky?
So it's from statements made by Kenneth Odom, there were two conversations between Courtney Odom and Kenneth Odom. The first one indicated a hypothetical, and at which time he told her that she should not get involved. According to Kenneth Odom.
When did that conversation occur?
It occurred on the 12th at some point.
Okay. And the second conversation?
Was either late on the night of the 12th or early on the morning of the 13th.
When did the conversations happen with the grandmother?
I believe the majority of them took place on the 14th.
You mentioned that there were at least 50 officers from Texas and 40 officers from other states involved in this investigation. Is that correct?
That's correct.
And it would be safe to assume that we'll be seeing reports and videos and audio from all those individuals. Is that correct?
So the FBI has turned over the majority of what they call a 302, which is a narrative by each individual officer that took some sort of action. In many cases, those agents worked in pairs, and so only one of them wrote. But there are extensive narratives that we are assembling at this point as we try to draw a conclusion to the investigation.
Is it safe to say, based on what you testified to, that when Willow Sermons was left in Kentucky and my client went to see her grandmother, that my client was going there to care for her son and not in any attempt for herself to flee? Is that correct?
Well, certainly her change in location was to separate herself from the victim in an attempt to continue to elude law enforcement until it suited her.
And I understand that may be your opinion, but what you testified to was that the reason she went to Missouri to see her grandmother was to get her son to a family member in a safe situation. Is that correct?
Prior to her being arrested, that's correct.
Okay. And you're sure that you found $3,000 in the possession of my client, Courtney Odom. Is that correct?
I did not find $3,000. An FBI agent out of the Tyler office recovered $3,000 from Courtney Odom's diary.
So what you're telling the court, what you're telling me is that you're basing this report to the court under sworn testimony as being secondhand knowledge from other officers that you weren't present in any of this investigation.
Well, I have their reports that do that.
But that's correct to say that you haven't seen the money or know what the money amount is firsthand.
That's correct. I wasn't there.
Okay.
It was an FBI special agent.
Okay, I pass the witness.
State, any follow-up questions?
Briefly, Judge, when Willow Sermons left her home, Sergeant, whose vehicle and what people were present?
She got into Courtney Odom's car with Courtney Odom and Austin Walker and Courtney Odom's infant son.
Did Courtney Odom and Austin Walker know each other prior to this?
Yes.
Have you been able to determine how long they've known each other?
I have not.
Where is Austin Walker from? What city does he live in?
I'm not sure that he had an established residence. He did graduate high school in the Grand Saline area, but he seemed to be estranged from his mother and his father.
I'll pass the witness, Judge.
No further questions.
Any further witnesses or evidence from the state? Any further witnesses or?
I'm sorry, Judge. No, Your Honor.
All right, can Investigator Keltner be excused?
He can.
All right, thank you, Investigator Keltner.
Thank you.
All right, Mr. Manning, would you like argument?
Yes, Judge.
Go ahead, sir.
Judge, I think the state's contention here is twofold. They want to say that, first of all, that my client is somehow a flight risk, and second of all, that somehow she has the amount of money to make a $500,000 bond. Judge, I think the evidence shows otherwise. First of all, we've established that she was going to visit her father in Kentucky. That was her base for going to that particular location. Now that her father's arrested, she has no reason to go up there. She has family here in Tyler, Texas. She's lived with that family there. She lived in East Texas all her life, as you heard the testimony. She works here locally. She has a young child. All those things are things that anchor her to this community and ensure her appearance in the future. Judge, you heard testimony from Investigator Keltner. The sole reason that they have evidence of her leaving Kentucky and going to Missouri to meet her grandmother was so that her son would be safe. That's my client's. Once my client realized the situation she was in, she took steps to protect her son, not to protect herself, not to flee further, go further underground, but to protect her son. And for those reasons, I think those are compelling reasons why a $500,000 bond is not only excessive, but it's oppressive in this case. And we ask for the PR bond of $50,000.
State.
Your Honor, in this case, in this offense, where this defendant traveled through multiple states to avoid detection while having a child secreted in her car, a PR bond is absolutely, Your Honor, not appropriate. It is our belief that the bond that this court set initially, based on the information in the arrest warrant affidavit, was totally appropriate. I believe this defendant's actions show that she is a flight risk. She picked up a child, a person who is obviously intellectually disabled. She lied to her own family about who that person was. She traveled to Louisiana. She traveled to Tennessee. She secreted the child from law enforcement in Tennessee, didn't reveal anything that's going on, calls her father. Her father tells her, get out of that situation. She doesn't. She keeps traveling. She goes to her father's. Maybe it's commendable that she wanted to protect her son, so she traveled through 2 more states to meet her grandmother and protect her son. But it would have been a lot easier just to walk into a local police department and protect her son that way and say, look, I did this, it isn't good. But she didn't want to get caught. She didn't want detection, and she kept staying on the road. And that is our concern, Your Honor. She has little to no family ties here. She'll lie to her own family. She has no significant work history that she would stay here, around here for. Nothing that holds her here. And we think that for this offense and the danger that that child was put in, the bond the court originally set is completely appropriate, Your Honor.
All right, and how Odom? Odom's 21, is that correct?
Yes, Judge.
All right. All right, the court's going to stand in recess for about 5 minutes, and I'll come back with my ruling on this. So about 5 minutes.
I'm gonna do this real quick.
If you can hear us, Judge, you're still on.
Yes. All right, sorry. Everybody hear me okay?
Yes, sir.
All right, we're back on the record in WR 20-37, ex parte Courtney Odom. The court, after receiving the evidence, the court has considered the nature and circumstances of the alleged offense. The court has also considered the accused's ability to make bail and also the future safety of the alleged victim and the community. The court denies the defendant's request for a $50,000 personal bond. The court will reduce the bail in this case. The court sets bail at $150,000 and finds that that amount is sufficiently high to give the court reasonable assurance that it will be complied with. And the court orders that the defendant's bail be conditioned upon the attachment of an active GPS unit upon the accused prior to the posting of any bond. Before the accused posts that bond, prior to the accused being released from the Van Zandt County Justice Center, an active GPS unit must be attached upon her. Anything further, Mr. Manning?
Nothing from the defense.
Anything further from the state?
No, Your Honor.
Okay, the court will draft that order and forward it to the Justice Center, and I'll have a copy to be sent to both the state and to the accused, Mr. Manning.
Thank you, Judge.
Thank you.
All right, if there's nothing further, then that will conclude this hearing. And as for the state, I believe that concludes, I think maybe we have one more. And we'll find my docket here.
We do on our list, Judge, Mr. Williams.
Yes, Mr. Williams. Is he available?
He can be brought up as soon as Ms. Odom is taken back.
All right, thank you. I'm going to contact Deputy McLeish and ask her to call the name Tony Scott, Anthony Scott in the call. Ms. Burns, do we have an update on Ms. Smith? Did we get the $15 worked out? I noticed that she's not here. All paid, so she's good. She's going to expire on her own. Okay, good. Ms. Burns, could you modify that to add, could you do these and do this and add a GPS unit? All right, Mr. Williams, you are John Charles Williams, is that correct?
Yes, sir.
All right, Mr. Williams, we are set today for an arraignment in attorney status, and I need to know, have you hired an attorney to represent you?
No, sir.
And why not?
Due to everything that's going on, my family, is struggling with going back to work and haven't been able to finish paying the attorney yet or finish raising the money. So
How long am I supposed to let you sit out in the jail until you have enough time or your family has enough time to hire an attorney? Am I supposed to leave you out there a year, 2 years? How long? How long is it going to take?
Sir, I would hope not. The attorney I've been talking to, he's familiar with the case. And he is a court-appointed attorney. But, I mean, I don't know if you can appoint him to me or not. If you could, that would be great, sir.
Well, all right. Well, I'm a little confused. So what attorney have you been speaking with?
Daniel Hunt. I've only spoke to him once, and I was out then. You know, I was.
Well, I understand. Okay, so, all right, so just a second. So my recollection is that Mr. Hunt has represented you in the past. Is that right? Or he's currently representing you on another court-appointed case?
No, sir.
No?
No, sir.
Well, Mr. Hunt is not on the court appointment list. So the court can't appoint him because he doesn't want to be appointed.
Right.
So that resolves it. So that resolves that issue. I can't appoint him to you because he doesn't want to be an appointed attorney.
Yes, sir. Yes, sir.
So you can hire Mr. Hunt.
Can I have 30 more days to come up with the money to because I'm almost there, Your Honor. I'm almost there.
How much do you have saved?
4,000. I need 5.
How much? You need 5.
Yes, sir.
And how are you getting the money up while you're sitting in jail?
My wife. If it wasn't for my wife, I wouldn't get it done, sir. I was trying to go to the law library, but it's broke a lot. So to file for a dismissal on it, the blood draw, I was
okay.
on
So Mr. Williams, are you wanting to represent yourself?
No, sir. I don't think that would be a good idea.
All right, then I don't want to hear any more about law library and filing motions to dismiss and arguing evidence. Now, if you want to represent yourself, we can talk about that. But if you're really asking me if you can have 30 more days, my only concern, Mr. Williams, is what happens in 30 days and you don't have the money. Then that would have made 90 days that the taxpayers have paid for you to sit in the jail. And it's my job to make sure that you're not just sitting there in jail. And that would be 90 days of preparation time that you've lost on your case.
Yes, sir. If you would like to go ahead and appoint me one, and if they get the money, they can hire the.
Well, that's not how it works, Mr. Williams. I don't say, hey, taxpayers, I'm gonna go ahead and use your money on these court-appointed lawyers up until Mr. Williams decides to write the check. That's not how it works. You have refused to complete the affidavit of indigency. And I understand that if you're not indigent, I'm not going to appoint you an attorney, and I'm not going to spend the taxpayers' money on hiring you or on giving you an attorney just so you can later say, I don't want that one. I'm going to hire my own. So this is what I'm going to do. I'm going to give you 30 more days. Okay. I'm going to give you 30 more days. And the next time we come back, if you don't have the attorney hired, maybe you need to talk to other attorneys who are less than $5,000. That's just something for you to think about. If you have the money and do not have an attorney hired, then we're going to have a discussion on whether or not you're going to represent yourself, because you're going to put the court in a position if you're not indigent, meaning you don't financially meet the requirements for court-appointed counsel, then the courts can't appoint you one. And if you're not going to hire one, then you really only put me in a position to only do one thing, and that's to discuss with you representing yourself. And the court may have to put you in that position, and then you can battle the state and their lawyers and their trained officers and all their evidence. And looking at my docket, it tells me that this is a habitual felony offender case, meaning potential range of punishment is 25 to life. So what I'm trying to do, Mr. Williams, is light a fire. And I know that if things are slow, and I understand that, but you're in a situation right now that you need to pull out all stops, and you need to get legal representation, and you need to get them to this court so we can get the movement on this case, because you're the one whose liberty is sitting in that Van Zandt County Justice Center.
Yes, sir. Your Honor, if I could, Your Honor. Your Honor.
I'll give you the 30 days, but I'm telling you, you need to get on the phone. And if you've got property to sell, if you have assets to sell, now is the time to do it. Don't wait till day 29 and then come back and say, hey, Judge, I need 30 more days. That's not going to work. Okay?
Judge?
Yes.
Can the court hear me?
Yes.
Okay, Your Honor, some information for both the court and Mr. Williams that may play into his ability to retain an attorney. As I mentioned earlier this morning, the grand jury met last Friday. There was a case for felon in possession of a firearm on Mr. Williams that was presented to the grand jury. They've returned a true bill. That is cause number CR 20-146. So I just want to make everybody, the court and Mr. Williams both, aware of the fact that there is a new indictment in this case, which may again impact his ability to retain an attorney, as that may make a fee higher since there's a new indictment now.
All right, thank you. All right, Mr. Williams, you understand what Mr. Cox has said?
Yes, sir.
You now have a second case.
Yes,
And-
sir.
And as it goes, attorneys usually charge more for each case that you have. So you need to discuss that within these 30 days. You need to find out who can represent you on the two charges for the amount that you have.
Okay, yes, sir. He is aware, the one that I've been talking to is aware of the new charge. So, yes, sir. If I can have 30 days, I will do my very best to have him ready in 30 days.
Mr. Williams, is the $5,000 quote, is that based on two charges?
Yes, sir.
Okay, good. All right. Well, I'm going to give you the 30 more days, and I fully expect I'm going to give you till August 4th. Okay.
Yes, sir.
And I expect on August 4th that Mr. Hunt has filed a letter of representation, or you have contacted my indigent defense coordinator, Mr. Abraham, and you have filled out her paperwork. One of the two.
Yes, sir.
All right.
Yes, sir. Thank you very much.
All right. You're excused. All right, Mr. Cox. Thank you, sir. I believe I think that concludes our docket.
I believe so, Judge.
We've had Mr. Scott's name called 3 times in the hallway with no response. Is that correct?
That's correct, Your Honor.
All right. Court has called CR 13326, State versus Tony Anthony Scott. Mr. Scott has not appeared in the courtroom, nor has he contacted the court about being late today. Therefore, the court hereby issues an alias capias and revokes his personal bond, and I will take that under advisement until noon on Thursday, after which time, if Mr. Scott has not availed himself before the court will have that alias active at the sheriff's office. All right, Mr. Cox, I believe that's all, sir.
All right, thank you, Judge.
Hey, let me ask you real quick, Mr. Cox, let me